Self-defense in the law, what every civilian needs to know. Self-defense is a basic human instinct, the desire to protect ourselves and our loved ones from harm. However, in the eyes of the law, defending yourself is not always as simple as fighting back. While the law in most jurisdictions recognizes the right to protect oneself, there are very specific rules about when, how, and how much force can legally be used. For the average civilian, someone without law enforcement or military training, understanding these legal principles is crucial. A failure to understand the legal framework of self-defense could turn a justified reaction into a criminal offense. This essay explores the legal considerations civilians should be aware of if they ever find themselves in a self-defense situation. 1. Understanding the legal definition of self-defense. At its core, self-defense is a legal justification for using force to protect yourself or others from imminent harm. But for this defense to be valid, certain conditions must be met. A. Imminent threat. The threat must be immediate and unavoidable. If someone threatens to hurt you next week, you cannot lawfully use force against them today. The danger must be present and real at that very moment. B. Proportional force. The amount of force used must be proportional to the threat. If someone slaps you, using deadly force in return would likely be seen as excessive and unjustified in court. You're expected to use only the level of force necessary to neutralize the threat. C. Reasonable belief. You must reasonably believe that you or another person are in danger of being harmed. Even if it turns out the threat was not real, your belief must be one that an average person would find rational under the circumstances. 2. The difference between non-deadly and deadly force. Understanding the distinction between non-deadly and deadly force is critical. A. Non-deadly force. This refers to force not likely to cause death or serious bodily harm. Examples include pushing someone away, using pepper spray, physically restraining an aggressor. Non-deadly force can generally be used to stop a physical assault or trespassing, provided it's reasonable and necessary. B. Deadly force. This refers to any force that is intended or likely to cause death or serious bodily injury. Examples include shooting someone, stabbing with a knife, striking with a heavy object to the head. Deadly force is only legally justified when you face an imminent threat of death or serious bodily harm. Most states also allow deadly force in defense of others under similar conditions. Third, duty to retreat versus stand your ground. Your geographic location matters greatly in a self-defense case, especially regarding whether you had a legal duty to retreat before using force. A. Duty to retreat states. In these states, you must attempt to escape or avoid the conflict before resorting to force, especially deadly force, unless you're in your own home. B. Stand your ground states. In states with stand your ground laws, you do not have to retreat if you're in a place where you're legally allowed to be, even if you could safely escape. You can meet force with force, even deadly force, if you reasonably believe it's necessary to prevent harm. C. Castle Doctrine. Most states apply the Castle Doctrine, which holds that you have no duty to retreat if someone unlawfully enters your home. In some states, this doctrine extends to your vehicle or workplace. Key takeaway: know your state's laws. The legal path you follow in Texas may be very different from the one in New York or California. Fourth, defense of others and defense of property. Self-defense laws often extend to defending other people and in some cases defending property. A. Defense of others. Most states allow you to use force in defense of another person, but the threat must be immediate. Your belief that they were in danger must be reasonable. The force used must be proportional. In legal terms, you often stand in the shoes of the person you are defending. If they would have had the right to use self-defense, so do you. B. Defense of property. You generally cannot use deadly force to protect property alone. For example, if someone tries to steal your car or break into your garage, Using lethal force might not be justified unless you reasonably believe they pose a threat to your life or safety. 5. The importance of perception and witnesses. In court, how the situation appeared to others can be just as important as what actually happened. Witness statements, security footage, and even your body language can influence whether a jury believes your use of force was reasonable. Consider these questions. Did you try to defuse the situation? Were you acting in anger or fear? Were you the aggressor or defender? If witnesses say you looked aggressive, shouted threats, or escalated the situation, the prosecution may argue that you weren't defending yourself. You were looking for a fight. 6. After the incident, legal steps to take. Even if you acted in clear self-defense, the situation is far from over. What you do after the incident is just as important as what you did during it. A. Contact law enforcement immediately. Do not flee the scene. Call 911 as soon as it is safe to do so. Clearly identify yourself, report that you were attacked, and that you were forced to defend yourself. Be careful with your words. What you say to police officers can and will be used in court. You are understandably shaken and emotional, but it is critical to avoid making incriminating statements. You can say, "I was attacked, I was in fear for my life, and I want to cooperate fully." But you should also say, "I'd like to speak with an attorney before giving a full statement." This is not a sign of guilt, it is a wise legal precaution. C. Hire a criminal defense attorney. Even if you believe you are 100% justified, you should immediately consult an attorney. They will help you understand local laws, preserve evidence, and guide you through the legal process. 7. Civil lawsuits, even if you're not criminally charged. Even if the court agrees that your use of force was legally justified and you're not criminally charged, you could still face civil litigation. The attacker or their family may file a lawsuit for wrongful death, personal injury, emotional distress. This is why many firearm instructors and legal experts recommend self-defense insurance or legal defense memberships, such as USCCA or CCW SAFE, to help cover legal fees in both criminal and civil cases. 8. Avoiding escalation, the legal and moral obligation. While self-defense is a right, you are also expected to do everything reasonably possible to avoid violence. You are not legally justified in starting a fight and then claiming self-defense, provoking someone and retaliating when they react, chasing someone down after the threat is over. Once the threat ends, your right to use force ends. Continuing to attack, even if you were originally the victim, can land you in legal jeopardy. 9. Use of force by weapon or hands. How you defend yourself also matters. The use of deadly weapons, such as firearms, knives, or blunt objects, will always receive more legal scrutiny than using hands, fists, or non-lethal tools. That said, even using your fists can be seen as use of deadly force if the victim is significantly smaller, older, or weaker. You have martial arts or military training. The force caused serious injuries. This is why training in control, judgment, and restraint is vital. 10. Self-defense training and legal education. Being trained in self-defense is not just about fighting. It's about judgment, decision-making, and restraint. You should take self-defense or firearms training from certified instructors. Study your state's self-defense laws. Attend legal seminars or courses offered by reputable defense organizations. Know what to say and do after a use of force incident. A well-trained individual knows how to de-escalate a conflict, when to walk away, and when to fight only as a last resort. Conclusion: be prepared, be responsible. Self-defense is a legal right, but it comes with serious responsibilities. Every civilian has the duty to understand the legal boundaries of that right, to act reasonably, and to avoid unnecessary violence whenever possible. If you are ever in a position where you must defend yourself or someone else, the actions you take will be judged not just by what happened, but by how it appears to others and how it fits within the law. Remember, Only use force when necessary. Use proportional force based on the threat. Understand your local laws, including duty to retreat or stand your ground provisions. Avoid being the aggressor. Always contact legal counsel after a self-defense event. Being informed, prepared, and restrained doesn't make you weak. It makes you smart. It makes you safe. And it makes you a responsible citizen ready to protect yourself, your loved ones, and your future.